Good afternoon and welcome to this installment of the Foreign and Comparative Law series titled What's a Legal Gender? A Guide to Gender Self-Identification Laws in Europe. I'm Elin Hofferberg and I'm joined by Dr. Jenny Gestley, and we're both senior foreign law specialists here at the Law Library's Legal Research Institute. Our combined expertise cover mainly the German-speaking and Nordic countries as well as European Union law. Today's webinar will focus on a few select jurisdictions in Europe, most of which have seen recent developments in their gender determination legislations. Let's get started. First, here is an outline for what we will talk about today. We will start with defining the terms we will use throughout our webinar, specifically gender identity, legal gender, third gender, and self-identification gender laws. Please note that we will not look at legislations against discrimination, but focus on how to change the legal gender of a person. After that, we will look at what countries offer third gender options in their legislation. And already here, we want to note that this is an overview of select jurisdictions and not an exhaustive list of all gender legislation in Europe. After that, we will look at the use of X gender markers in passports and other identification documents, followed by other legal gender laws, and end with some select jurisprudence from the European Court of Human Rights before we take your questions.
Great, thanks Elin, and also good afternoon from me to everyone. We thought we should start the webinar by defining some key terms that we will be using throughout the presentation so that we're all on the same page. I would also like to find out that we will be using the terms that are used in the legislation of the respective jurisdictions that we're talking about. Okay, so our first term that we would like to define is gender identity. It is generally defined as an individual's internal sense of their gender. Someone's gender identity may differ from their legal gender, which is a term I will define in a second. The right to effective recognition of one's gender identity is linked to the right to equal recognition as a person before the law, which is internationally protected. For example, Article 6 of the Universal Declaration of Human Rights protects this. And obviously, even though the Universal Declaration of Human Rights is non-legally binding, it has been translated into binding law, and it has also been argued that it has become binding as part of customary international law. Another example would be Article 16 of the International Covenant on Civil and Political Rights. And this right it's also protected in, it's present in other universal human rights treaties, regional human rights instruments, etc. Okay, so next, let's define legal gender, the topic of our webinar. So legal gender is the gender as it is nationally defined in law and used in legal settings. For example, the gender used in civil registries, passports, other identity documents. Depending on the jurisdiction, there might only be binary options, so only male or female, or there might be additional options such as a third gender or a no gender option. And we will talk about which countries in Europe offer which options in a little bit. So now that we've defined gender identity and legal gender, you might wonder how and if a person may change their legal gender so that it conforms to their gender identity. Some of the jurisdictions we will talk about today have introduced gender self-identification laws for that purpose. Okay, so what are those laws? How are they defined? So gender self-identification laws, they usually only require a statement of the individual at the competent authority that their legal gender does not match their gender identity in order to change the gender entry. And as mentioned, we will talk about a few selected examples soon, but we won't be able to cover all the laws that are in place or have been proposed. So I would like to start off with another definition, third gender. As I've mentioned before, some jurisdictions allow individuals to register another gender besides male or female, the traditional binary options. Examples for a third gender are diverse, inter, open, or X. So if you see something like that, that's a third gender. And here you can, on our slide, we have a little map that identifies some of the jurisdictions that we've surveyed and whether or not they offer a third gender option. And I hope you can see that. Yes is the orange one and no is the grayish one. And like I said, it's just the ones that we've surveyed. So this is not exhaustive. So let's take a look at 2 of these countries that have third gender options. Germany in 2017, the German Federal Constitutional Court held that the German Personal Status Act is incompatible with the German Basic Law. The Basic Law is the country's constitution. And it said it's incompatible with the Basic Law to the extent that it only allows the registration of a male or a female gender at birth or no gender entry at all. So that was the law at the time. In particular, the court said that the Personal Status Act violated the complainant's general right to personality, and the general right to personality includes gender identity. Okay, so let me briefly summarize the facts of the case. In this case, the complainant was an intersex individual whose birth certificate indicated the female gender. However, the complainant did not permanently identify as either male or female, and therefore requested that the registrar's office change the entry in the birth register to interdiverse or simply diverse. The request was rejected, as well as the complainant's appeals against the rejection. And then the complainant filed a constitutional complaint. So the court in this case found a violation of the complainant's general right to personality, as I already mentioned. And it stated, and here I quote the court, "Gender identity is a constituent part of someone's identity, and gender assignment typically plays a key role both in a person's self-perception and in the way this person is perceived by others. The options available under the Personal Status Act meant that an intersex person had to accept an entry that did not correspond with their gender identity. According to the court, the Constitution, the Basic Law, does not require that gender options be binary. The Basic Law only reflects the social and legal understanding of gender at the time it was adopted. So it was 1949. The court says it has evolved. It concluded that the legislature could either completely abolish the requirement of registering a gender at birth or allow intersex people the option of registering a third gender, such as diverse, what the complainant suggested, or something similar. I would like to note that the 2024 German Self-ID Act, which I will talk about later in the presentation in detail, extended the third gender options to everyone and not just intersex individuals. So at the time, it was only the third gender option was only open to intersex individuals because that was what the case was about. A second country I would like to talk about with third gender option is Austria. In 2018, the Austrian Constitutional Court held that intersex individuals have a right to register in the Civil Status Register a gender other than male or female that conforms to their gender identity. So very similar to the German court. It stated that forcing intersex persons to register a male or female gender, but not offering an additional option, violated their right to respect for private life as protected by Article 8 of the European Convention on Human Rights. And I would like to say the European Convention on Human Rights has constitutional status in Austria. That means that individuals can base their claim directly on the European Convention on Human Rights. Briefly, the facts of this case. In this case, an intersex individual applied to change the current male gender entry in the Central Civil Status Register to either inter, other, ex, undefined, or a similar term, or to strike the gender entry in its entirety. Like in the German case, the request was denied by the registrar and the State Administrative Court of Upper Austria. And they stated that the law did not allow a different gender entry besides male or female. The applicant then filed a complaint with the Constitutional Court. The court decided to examine the constitutionality of the provision of the Personal Status Act on its own initiative. And here, in this case, the court stated that Article 8 of the European Convention on Human Rights, and we will actually hear more about the European Convention on Human Rights when we talk about select jurisprudence at the end, that it awards everyone the right to respect for private and family life, and that includes gender identity. It concluded that the right to respect for individual gender identity includes that individuals must only accept a gender description that conforms to their gender identity, or be free to not declare gender at all. With regard to the term used for third gender, the court cited various examples, but ultimately left it open which term should be used or could be used. It stated, though, that public authorities are allowed to examine whether a chosen term adequately expresses what it intends to convey. So it still has to be, it can't just be any term. The Austrian court actually referenced the decision of the German court that I just talked about. and stated that it was of particular importance, as pointed out by the German court, that gender assignment typically plays a key role both in a person's self-perception and in the way this person is perceived by others. So the difference between Germany and Austria is that in Austria, the third gender option is still only available to intersex individuals, whereas in Germany, as I've mentioned, it has been made available to everyone. So now let's talk about jurisdictions that have a no gender option. And here we have another nice map. Again, this is only the jurisdictions that we surveyed that are displayed on this map. So this map, you can see which surveyed jurisdictions offer a no gender option in civil registries or on identity documents. So that's either in addition to binary options or in addition to a third gender option. So with no gender option, that generally means that either the gender entry is left blank or the gender entry states something like non, neutral, or something similar. So in this map, you see we identified 4 jurisdictions that have a no gender option: Germany, Austria, the Netherlands, and Iceland. And you will hear about the Netherlands and Iceland when we talk about the gender self-ID laws in just a second. So I would like to point out that Germany and Austria, so they allow both. We just talked about the third gender entry, but they also both allow a no gender entry. So where it's left blank. In these cases, at least, they leave it blank. In the Netherlands, the law says that a birth certificate may include the statement gender could not be determined, but there's no regulation for third gender. Interesting though, in the Netherlands, with regard to third gender, courts have found that the time is ripe for the recognition of a third gender and encouraged the legislature to act, but so far nothing has happened there. With regard to Iceland, I would like to point out that at this point, that Iceland, even though there is no third gender option, they allow an X in passports. But Elon will tell you more about that later when we talk about that. Okay, thank you. And now back to you, Elon.
Thank you, Jenny. So this slide shows a map of the gender self-identification laws that we will be discussing today. We will discuss them in chronological order. And again, a reminder that these are not an exhaustive survey of all jurisdictions in Europe or even Northern Europe. And our webinar focus on the legal gender designations, but we'll use names and designations as provided for in the relevant legal acts of each jurisdiction. So we'll start with Denmark. Of the jurisdictions we surveyed, Denmark was the first jurisdiction to enable legal gender changes through a self-identification process. In 2014, the Danish Parliament amended its National Population Registry Act, also known as the CPR Act, to allow for resident citizens aged 18 and over to change their registration in the National Registry, specifically changing their personal numbers from a male number to a female number or from a female number to a male number. In Denmark, persons are registered at birth as male or female and receive a lifelong personal identification number. Or if they're not born in Denmark, they receive that number at the time when they start to reside in Denmark. Because Denmark's personal identification number system, known as CPR numbers, are 10, where the 10th and final digit designates the gender of the bearer of the system, the registration process only offers binary choices. So you can only register as a male or female with the National Registry. Changing that registration includes receiving a new identification number is done through a written notification that the person perceives one identity to be of the other gender and is subject to a 6-month waiting period for the change to take effect. Again, these changes are only binary. However, its legislation on passports and IDs allow for no gender designation in the form of an X marker for passports, but is subject to some restrictions that I will talk about as we talk about X markers for passport later. Prior to 2014, the process to change one's legal gender in Denmark included a requirement to undergo surgery. So this was a big change when it happened. Of the Nordic country, Denmark is the only country without what we call a standalone gender-specific legislation, meaning it's actually dealt with in the CPR Act and not in an act called something similar to gender determination or similar. There has been a recent push to remove the reflection period that is currently 6 months and to allow minors, with the consent of their legal guardians, to change their gender, but no changes have been approved in Parliament as of yet. The next one is Norway. Norway adopted a standalone Gender Identification Act in 2016 at the same time as castration was removed in practice as a requirement for gender reassignment surgery. Under the new rules, written notification is required and the person must be a resident of Norway, meaning the person must be registered in the National Population Registry. A confirmation of the application is needed and requested through a letter sent to the person's legal residence. And then you have to, again, confirm that you want to make the legal change. Similar to Denmark, Norway uses personal identification numbers that include a reference to the person's gender. Why, again, the choices are only binary. The age requirement for changing one's gender is 16, but minors who are younger than 16 and older than 6 can apply together with their legal guardians, or just one of the guardians if it's in the best interest of the child to change the legal gender. People who are registered in the population registry as either a mother or a father will not have that designation changed, meaning a woman who wants to change her gender identification to male will still be listed as a mother to her children in the population registry. Prior to 2016, there were no standalone act on changing one's legal gender in Norway, but the Norwegian Tax Authority had in practice changed the legal gender of persons who were undergoing transsexual treatments at the Rikshospitalet, which is the research hospital in Oslo, at the request of the hospital. So the request was not made by the person him or herself, but by the hospital. So that's also a notable change in 2016. While a third gender has been discussed in Norway, because of the binary nature of the personal identification number system, a new system could not enter into force until 2032 at the earliest, when an update to the system is scheduled, and a personal identification number will become gender neutral, meaning the digits in the personal identification number will no longer correspond to a gender. In 2019, this is for Iceland. In 2019, Iceland adopted a Gender Autonomy Act, which specifically establishes in law that the right to one's own gender identity. The law provides that anyone aged 15 or above has the right through written notification to the population registry, register as either male or female or neutral. Note here that the personal identification number for Iceland do not include a reference to one's gender, which means that when you change your registry as either male, female, or neutral, you would not have to change your personal identification number. You would still be able to retain the same number if you compare, similar to like a social security number in the US. A person who is younger than 15 needs the support of its legal guardians to complete the application. However, a person who is younger than 15 who does not have the support of or both of its legal guardians as applicable can request that committee be established which will determine if the legal gender ought to be changed over the legal guardian's objection, and determine that determination must be based in the best interest of the child as per the UN Convention of the Rights of the Child. With respects to ID documents, persons who have elected to be registered as none or neutral in the population registry must be provided an X on passport and ID documents, and I will return to that a little bit later. An interesting thing about Iceland is because of how surnames or family names are formed in Iceland, typically by putting the father's name together with followed by son or daughter, changing one's legal gender also effectively means changing one's last name from parent's daughter to parent's son or vice versa. For example, Jónsdóttir or Jonsson, to reflect the new legal gender. And if a person registers as neutral or no gender, that person could be called Jonsbur, which means child of John. So that is a kind of a new invention of a last name that was not used in practice previously. However, I've come to understand that a common practice among persons who do not identify as either male or female is to just drop the ending of the surname. Instead of adding Bur, they would just call themselves Johns as a last name, without either son, daughter, or child affixed to it. So for example, Elin would be Elin Jones instead of Elin Jones Boer or Elin Jones daughter. We'll see what Switzerland has to say.
Great, thanks, Elin. Okay, so let's talk about Switzerland. Switzerland passed an amendment to the Swiss Civil Code and the Civil Status Ordinance in 2021 and entered into force on January 1st, 2022. So I guess this is also a country where there's no standalone self-ID law, but they just made changes to existing law. So these amendments allow transgender persons or persons with a gender variance to change their gender marker and first name quickly and without bureaucratic hurdles. So what you must do in Switzerland, affected person must simply state at the civil registry that they're firmly convinced that their registered gender does not match their gender identity, and then it will be changed. And then you can also choose one or more new first names once you've done this. Minors under 16 years of age or persons who are subject to various types of guardianship, they require permission from their legal representative for the change. It should also be noted that Swiss law only recognizes binary gender, so only male or female, and that the amendments did not introduce a third gender option or the possibility to leave the gender entry open in Switzerland. It has been discussed in Switzerland, and then in December 2022, there was a report from the Swiss government that looked at this issue of introducing a third gender options, no gender option, or striking all gender entries altogether. But it concluded that the binary gender concept is currently still firmly established in Swiss society, and that offering a third gender option or eliminating all gender entities would result in legal uncertainty, because so many laws would have to be amended. Okay, well, back to you, Elin.
Thanks, Jenny. So Finland adopted a new act on the confirmation of legal gender in 2023, so last year. It provides that a Finnish citizen residing in Finland who is at least 18 years of age may notify the population registry that it identifies as another gender than the one registered in the National Registry. A confirmation of the notification must be done no sooner than 30 days and no later than 6 months after the notification. This is just a way of showing some permanence to the change. There are only binary choices, similar to the other Nordic countries that have been mentioned today. Finland uses a binary personal identification number, where the last 3 numbers make up either an odd number, which indicates that you're male, or an even number indicating that you're a woman. Finland does not allow for third or no genders to be registered in the National Registry. The previous legislation, which this one replaced, required a medical diagnosis, and that partnership predecessor to same-sex marriages were converted into marriages. To also change the status as a mother or father, the person must apply and a notification will be sent to the other legal guardian of the child. So it's pretty straightforward and almost automatic, but it's still separate from the legal gender. So it's not automatic in the sense that as long as you become male or female, that your designation as mother or father corresponds to that, but you will have to make a little mark to do that. And then Sweden adopted legislation earlier this year, but it will not enter into force into next year. And its legislation allows persons who are age 16 or above to change their gender in the National Registry by contacting the National Board of Health and Welfare Services. The person requesting the change must make the notification in writing and indicate that it seeks to permanently change its gender and will continue to live in the new identity. A diagnosis of gender dysphoria is no longer required. There are only binary choices. Again, this is, I guess, the common theme of the Nordic countries. This is a result of the binary personal identification numbers, where the second to last digit indicates the gender of the person, of the bearer. For minors, the request to make the change in the legal gender must be co-signed with the legal guardian. So that's for persons aged 16 to 18 years old. When it enters into force, the law will replace the current requirements of a doctor's note confirming the gender identity and a diagnosis of gender dysphoria, and will displace the time requirement that was associated with the change. A previous castration requirement was removed in 2013. However, how the law will be applied in practice remains to be seen. But on its face, there's no waiting period or prohibition on changing one's legal gender back. The National Board of Health and Welfare may still issue regulations, however, and because the request must include a desire to permanently change one's gender, it is possible that this will become a prerequisite, and that it would person would not be considered to be meeting this prerequisite if it seeks to change it back too soon after that would violate the permanency requirement. Also, if there are other, it's not yet clear how if there are any other requirements that the National Board of Health and Welfare will put up. So there's a little caveat for how self-determined this one is, or if it should be moved to another section of our presentation, which includes jurisdictions which are more restrictive. So, but we'll see what the future holds for Sweden. Let's see for one that is much more specifically and is Germany. It has quite a substantial written text compared to Sweden. Thanks, Jenny.
Yeah. Okay. So let's talk about the German Act. So the German Self-Identification Act, it's a fairly also, like Sweden, a very new law. It was passed this year, and it will enter into force on November 11th, 2024. So that's, in a few days, 2 weeks about. So this law allows individuals to change their gender entry and first name at the civil registry without any bureaucratic hurdles. And Elin already mentioned that the German law is actually very detailed in comparison to other self-ID laws that we're talking about today, or that we have talked about before. I mean, normally it just is the procedure, but this law actually mentions a lot of additional points that it also includes a lot of clarifications that don't, like a lot of provisions that don't actually regulate anything, but they just clarify the legal situation. Okay. So what does the German self-ID law do? So first of all, it explicitly replaces the Transsexual Act from 1980. And that act established the procedure and requirements for changing one's first name and gender entry. So, but the Transsexual Act from 1980 only allowed changes between male and female. And it was also necessary to present 2 expert assessments that evaluated whether the applicant's sense of belonging was highly unlikely to change in the future. So the new law, this new Self-ID Act, on the other hand, it permits changing between female, male, diverse, and no gender entry. And also, and here again, this is what I said meant before. The law here also clarifies that changing one's gender entry is no longer dependent on the assessment of experts or other third parties. So this is explicitly in the act. So how does one change the gender and first name in the civil status register? Applicants must submit a so-called declaration with self-assurance to the registry office. And the registry office must be informed of the applicant's intent to submit such a declaration 3 months in advance, in writing or orally. So, but this is just kind of like a heads up, I will be submitting this declaration, so that's not the declaration itself yet. Then once they make that declaration, the applicants must affirm, 1, that the requested change best corresponds to the gender identity, and then 2nd, that they are aware of the consequences of the declaration. Once this is made, the change becomes effective 3 months after the declaration. It should also be noted that Germany introduced a so-called blocking period, meaning individuals are bound by the declaration for a minimum period of 1 year. So this is also why, you have to make the statement, you're aware of the consequences. So you can't just change it back the next day. With regard to minors, minors may also change their gender entry and first name. Minors 14 years or older need the consent of the legal representative. if the legal representative does not consent, the family court may substitute the consent if the change of gender and first name is not contrary to the best interest of the child. So we've heard that before when Elon mentioned the committee. In the case of a minor younger than 14, only the legal representative is permitted to make the declaration for the minor to change the gender entry and first name. But in this case, anyone 14 years or younger, if the child is 5 years or older, the child's consent is still required. So this is also so here again, it's the best interest of the child, also coming from the UN Convention on the Rights of the Child. Yeah, that's it for Germany. Like I said, there's lots more detail in the German law, a lot of things that I haven't mentioned, but we might be able to talk about that in the Q&A. The Netherlands does not have a Self-ID Act yet, but it has one was proposed in 2021. The draft is currently being debated by the House of Representatives, but it's unclear how long the legislative process will take. But I will just tell you about what the draft says so far. So the law would abolish the current age limit of 16, which is required to change one's gender entry. With regard to the process of changing the gender entry, an applicant would need to submit first. So first they need to submit the statement in writing to the civil registry that they are convinced that they belong to the opposite gender. So the statement then must be confirmed in person at the earliest after 4 weeks and at the latest after 12 weeks. So this is similar to Germany. However, in the Netherlands, we have the actual declaration that is submitted in advance. Whereas in Germany, it's just the intent that is announced, whereas the actual declaration is made at the civil registry. The Dutch law would allow multiple changes of someone's gender entry. However, there's a rule which says that the third and then subsequent changes would require a court order. So before you can just go to the civil registry, afterwards you need to go to court. So the court then would need to examine in such cases whether the request is genuine and well considered. The draft law does not say what that means, what the court would have to take into account. So we'll see when it's actually adopted, what happens. With regard to minors, I already mentioned that the age requirement is going to be removed. But it's actually, the draft law would do two things actually with regard to minors. So currently, minors 16 and older may only change their gender entry by submitting a request to the court through an attorney. So this requirement would be removed so that minors under 16 years of age, they would also be allowed to change their gender through an application to the court. So anyone could do that. But in addition, the draft would allow minors over 16 of age to change their gender registration without the intervention of a court. So like everyone else, so the Dutch law would allow anyone 16 years or older to just make the declaration at the civil registry, and then anyone younger has to go through an attorney and the court. Okay, so back to you, Elin.
Thanks, Jenny. Yes, to sum up, you see that there's quite a bit of similarities. Some common features of the self-term relations law that we have surveyed. For example, almost all of the laws are standalone laws dealing specifically with gender self-determination. And there are no requirements for mandatory surgery, expert opinion, or divorce. Most of the countries surveyed also require the person who's changing their gender to be, if not 18 years old, at least 16 years old, and a resident of the country where the legal change is sought. However, several countries also allow for minors to change their legal gender, typically with the consent of the legal guardians of the child. Notably, Iceland allows persons younger than 15 that do not have their legal guardians' approval to seek permission from an ad hoc committee. So they have a special system for when a committee should be formed. And the youngest legal gender change was in Germany, where all minors may change their gender if done with the legal representatives And for minors age 5 and up, the legal representative must also include a request from the child, as Jenny mentioned, the consent of the child, that this is not the parent doing it. It is also the parent and the child together changing the legal gender. All jurisdictions also, in one way or another, seek to guarantee some kind of permanence to the new legal gender change, either through write-out bans on changing a legal gender within a certain time period, or by applying a waiting period for the change to take effect, or by requiring that the person seeking the change state the change is intended to be permanent, or that they confirm it through a two-step process. For instance, if you send in the notification and then you get a letter back and then you confirm the notification. And that's just a way it seems to make sure that people are not hastily doing this and that they later regret it, as it no longer requires any other changes.
Thanks, Elin. So we thought it would be informative to also talk about some European jurisdictions that are more restrictive with regard to changing one's gender entry, and with regard to the available gender options than the ones we've talked about so far. We picked 2, Bulgaria and Georgia, as examples, mainly because they have been in the news lately. So you might have heard about these legislative developments. So our first example is Bulgaria. In Bulgaria, a person's gender is recorded in the National Population Register. If a change of the gender entry is approved, the original entry will not be deleted, and the change will only be noted in a so-called note section. So the original name is still there, and so they call it a dead name. I would also like to talk about 2020 Supreme Court of Cassation decision in Bulgaria, which is important in this regard. So in 2020, the Supreme Court of Cassation in Bulgaria issued a ruling on changing one's gender in government documents. So it referenced actually the European Court on Human Rights, and held, and we will actually talk about some of those cases later that the court referenced here. And held that a person must not be required to undergo surgery for gender reassignment, but that hormone therapy is sufficient. However, so as I understand, Bulgarian law does not provide, it allows changes in the gender entry, but it does not provide a procedure for changes in the gender entry in the legislation. So the court said that it must be derived from Article 8 of the European Convention on Human Rights, which sounds difficult. So this ruling then led to contradictory subsequent court decisions and ultimately resulted in a 2021 Constitutional Court decision. So the Constitutional Court then held that gender in the Constitution refers solely to biological aspects, and that the country's current legislation did not allow courts to admit proceedings to change someone's legal gender in government documents. So according to the court, gender is not a personal choice or a social category. Also interesting, the Bulgarian parliament has been debating several legislative proposals to amend the Child Protection Act, and so also passed similar legislation. It passed an amendment to the School Act in August of 2024. And this amendment prohibits what they call LGBT propaganda. So that means that any discussions even about that there are other gender options besides binary gender, or that there's gender reassignment or gender transitions, that is possible, those are prohibited. So similarly, Georgia, in 2024, Parliament approved the law on the protection of family values and minors in September of 2024. So, and in particular, this law was in the news, so you might have read about this. Among other things, this law prohibits gender reassignment surgery, and it also said that there's only binary options for gender entries in government documents. The president of Georgia actually declined to sign the law on October 2nd, 2024, But the Speaker of Parliament signed the bill into law instead on October 3rd, 2024. So that's, I guess, an option in Georgia. So this law is in effect currently, but has been criticized. Okay, so just, yeah, those were just a few select restrictive examples. And now back to you, Elin.
Thank you, Jenny. So this one, this map shows the X gender markers in passport and IDs. For our listeners here in the US, the X gender marker in passport should be somewhat of a familiar feature. If you've applied for a passport recently, you might have seen that you can choose between male, female, and X on the passport application itself, starting in 2022. The X gender mark in passport has briefly been mentioned during the individual jurisdiction presentations that we had just a minute ago. But we wanted again to highlight the use in Iceland, Denmark, Germany, and the Netherlands and Austria. Most notably, the jurisdiction surveyed, Denmark and the Netherlands both only have binary options for their legal gender definitions, but nevertheless allow for the use of X as a gender marker in their actual passports. For example, the Netherlands, that practice is the result of a court precedent. And as we already heard from Jenny, the Netherlands allow gender cannot be determined in a birth certificate, but that does not mean that an X is automatically included in the passport. So that's a separate application process. In Denmark, the use of X markers is the result of the Passport Act, but is still subject to some restrictions. Specifically, as a general rule, the Danish passport information will be based on the information registered in the National Registry, which includes the legal gender. However, the Danish Passport Act also provides that a passport applicant may provide a written notification stating a desire to use X as the gender identifier in the passport because the person identifies as another gender, no gender, or because of prior changes to one's gender. So the X gender mark is not available to everybody. You will have to meet one of those conditions. And in the cases where the X marker is used, the X will not reflect the gender specified in the National Register or correspond with the CPR number registered. So it's kind of like a third category in itself. Similarly, Iceland will use the gender from the population registry for the passport application. And a person who has registered as a no gender with the National Registry must be assigned X in the passport. So that if you are neutral, you have to have X in that. There's no option there. That said, while other jurisdictions surveyed, such as Sweden, include gender data in their biometric information of the passport, it is not actually displayed in the passport itself. So if you simply open a Swedish passport, it will not indicate the gender of the bearer. And this may actually be true for several other jurisdictions as well. So that's something to that might be interesting to know. And then we wanted to talk some about some other legal gender laws. Jenny?
Thanks, Elin. Yeah. We just called this yeah, other legal gender laws or legal gender laws with requirements. Because yeah, we wanted to there's other jurisdictions where you are allowed to change your gender entry. But instead of just a statement, you have to fulfill other additional requirements. So I will briefly talk about Austria as an example of one of those jurisdictions. So in order to change one's legal gender in Austria, a person must fulfill the following requirements. So first, you must have submit proof of your trans identity. So in Austria, that's defined, trans identity means a person is medically assigned to a gender, but feels incorrectly or inadequately described in this gender, or rejects any form of gender assignment and categorization. That means their gender identity does not match their gender entry. So what do you need to do for this proof? So the highest administrative court in Austria requires that a person who would like to change their legal gender has 1, an irreversible feeling of belonging to the other gender, and then 2, you need a clear approximation to the external appearance of the other gender. So as a rule, this can only be sufficiently clarified by obtaining an expert opinion, so either from a psychiatrist, psychotherapist, or clinical psychologist. So they have to confirm that these things are true and in evidence. It should be noted that having undergone gender reassignment surgery or divorce is not a requirement for gender entry change in Austria. As mentioned, when we talked about the third gender, intersex persons in Austria may also change their gender entry to the third gender option. So available are diverse, inter, open, or no indication. But then in addition to the expert opinion proving the trans identity, intersex individuals also need an expert opinion which confirms that they cannot be assigned to either the male or the female gender. So once you fulfill those two requirements, you can change your gender entry. The gender entry must be changed before a new and gender-specific first name may be adopted in Austria. So one has to be, one has to be done before the other one. You can't do it at the same time. Okay, so let's talk about some select jurisprudence from the European Court of Human Rights. And I already mentioned the European Court of Human Rights and the European Convention on Human Rights in various other slides that, before. And there's a lot of jurisprudence from the court, especially with regard to discrimination, which we'll, as Elon said, not talk about today, which would be a whole other webinar. But you can certainly look that up on the court's website. And we just picked two cases that show how the European Court of Human Rights approaches gender identity. So the first case is basically the starter case is Christine Goodwin versus United Kingdom. It's a 2002 case. And in this case, the European Court on Human Rights found a violation of Article 8, the right to respect for private and family life. And we've talked about this before when we talked about Austria and the third gender. So the court there mentioned Article 8 as well. And it also found a violation of Article 12, the right to marry and to found a family. But I will now, for the sake of time, just focus on the violation of Article 8. So in this case, the applicant, Christine Goodwin, was a post-operative male to female transsexual. But legally, the applicant was still considered a man and faced difficulties concerning her national insurance contributions in the UK. So she complained about the lack of legal recognition of a post-operative gender change and about the legal status of transsexual in the UK. So the court found that there was a continuing international trend in favor of not only increased social acceptance of transsexuals, but also of legal recognition of the new gender identity of post-operative transsexuals. So these are, so they affirmed basically minimal obligations for member states to provide legal gender recognition or gender identity. That, However, it stated that countries have wide discretion to impose preconditions for changing the legal gender entry. But that was in 2002. Fast forward to 2021, I picked one of the cases, which is called X and Y versus Romania. So since the Goodwin case in 2002, the European Court of Human Rights has adopted a stricter lens of review and has condemned, for example, sterilization and surgical requirements. Like I said before, I mean, in the 2002 case, it said the state countries have wide discretion to impose preconditions, but since then, it says, well, some are violations of the European Convention on Human Rights. So in the case of X and Y versus Romania, the court found that the domestic authorities' refusal to legally recognize the applicant's gender reassignment in the absence of surgery had amounted to unjustified interference with their right to respect for their private life in violation of Article 8. So in this case, the applicants, they did not wish to undergo gender reassignment surgery. So the court stated that they were faced with an impossible dilemma. So either they had to undergo the surgery against their better judgment, which affects their physical integrity, or they could forego recognition of their gender identity, which affects their private life. So that was also a very important case from the European Court of Human Rights. Okay, now back to you, Elin, to wrap it all up.
Thank you, Jenny. Yeah, as you can see, that concludes the presentation part of our webinar. And it actually looks like we have some time for questions. If you have not done so already, please submit your questions using the Q&A feature. Let me see. Okay, so here's one question. Do the gender self-ID laws that you have surveyed say anything about what effect changing one's legal gender has on existing family law relationships or on the access to gender-specific facilities? Oh, that's a big question. Jenny, do you want to start?
Sure. I mean, I guess this question has two parts. So let's start with existing family law relationships. So normally, most of the countries I've surveyed, the change of the legal gender has no effect on existing family law relationships. But interestingly, the German law, I already mentioned, it's very detailed. So the German law says with regard to future family law relationships, the gender entry at the time of a child's birth is decisive for the recognition of the father. So this means, for example, that only those who are registered as male at the time of the child's birth will be recognized as the father. However, the parent may submit a declaration to the registry office indicating that their prior gender entry should be considered decisive. So then you would not have that problem. So I thought that was interesting that they have, that they did it like that. I don't
You
know
can
about
tell
you.
that the German ID law seems to be much more specific than most of the other laws that we surveyed were more general, which and only dealt with legal gender changes, and then that relationship versus you had to, for the familial status, you would have to make a separate application to change that. So you would have cases where you were a legal male, but you would still be registered as mother of your children in the civil registry, which is, interesting. And I think that was throughout, actually, compared to the other ones. With respect for the facility one, it's the same, at least for my jurisdictions, they did not, the legal gender determination law does not cover access to gender-specific facilities. So that is a completely separate issue. But on that issue, there was a recent case from the Supreme Court in Denmark that was issued just last month. So in early September, the Supreme Court found that there was a person who had changed their legal gender identity from male to female after being convicted for rape of another female. And that person was then seeking to be transferred to a prison for only female inmates. And that request was denied at first at the lower court, then the appellate court, and then finally at the Supreme Court. And the reason for that was that they said, even though there is generally, if you're registered as a legal, your legal gender is typically what determines where you will be placed in prison. There is a concrete and holistic assessment in cases where your legal gender does not conform to your biological sex, or when there has been a change after sentencing. And in that specific case, they looked at several issues, including the fact that there was a board who had said that there was a risk that the person would fall back into crime, that there was a risk that there was repeat of the crime she was convicted for. They also looked at the risk for other inmates at the other one, and they looked at the kind of the amount of, how does this violate Article 8 to be together with males in a prison setting, and then on the whole, the Supreme Court came to the conclusion that it did not, that the person in question did not have an absolute right to be transferred to a female prison.
Yeah, that's interesting actually. So most of my jurisdictions do not have specific rules on access to gender-specific facilities, so the general rules apply. The German law, though, again, has a rule on it, but I mentioned at the beginning that there's a lot of provisions in the German Act that are just there to clarify the legal situation, and this is one of them. So it says with regard to access to gender-specific facilities, participation in events, and so on, that freedom of contract and the domiciliary rights of the respective owner still apply. So that hasn't actually changed the current legal situation. So this is just about with regard to private parties. And I mean, you always have to take the General Act on equal treatment into account for that. But yeah, so this provision is in there because it's, I think, a question that's on everyone's mind. But it has not actually changed the existing legal situation. I think that probably answers the question. Should we see if there are any other questions?
Yes, there is. So we have one here. Can you please tell us a little more about the procedures surrounding minors changing their legal gender?
Okay, would you like me to start or would you?
Yeah, sure.
Okay. So I guess I already talked a little bit about minors. I guess a lot of times Elin mentioned that when she had our summary, that regularly parental consent is required for in most cases. Germany again is interesting because yeah, they had the lowest age limit or no age limit. I guess I think Iceland, where the committee is formed. In Germany, we have the family court that can replace the consent if that's not possible. What's also interesting, and I did not mention that, so normally when you submit the declaration of self-assurance that you want to change your gender entry, you do not need to fulfill additional requirements. But in the case of minors, they need to also, with the statement, submit another statement that they've received counseling before they submitted this change request. So that either has to be counseling from therapists, psychiatrists, psychoanalysts that focuses on children and adolescents. And in the case where the legal guardian submits the change, it's not a requirement, but if the person is under some kind of if the minor is under some kind of guardianship, the guardian needs to attend this kind of counseling and submit the statement. So that's, I guess, also an additional procedure that's just required for minors.
Yeah, that's very interesting. For Iceland, it's not as specific. They use, the state that there has to be an ad hoc committee created, and that they will have to determine what is in the best interest of the child. So already there, I think you can say that, well, that will not be as a straightforward process as you're sending in your notification, right? It will be, you will have to show some kind of proof or evidence, or at least supporting documents that show why it would be in the best interest of the child, so that it's from that alone, it's quite a big difference from just being an adult when they as an adult change your legal gender, as there's no supporting documents, or you don't need to state that it's in your best interest. You just need to show that, indicate that in your notification that you are intend to be the net gender, and that this is some kind of permanence. So, and I thought it was interesting also that almost all jurisdiction had some way of, even though there was an 18-year limit, almost all of them except Denmark and Finland had some way of doing it without, you know, with parental consent. Some of the jurisdiction also that we haven't mentioned, they also have that if you are truly intersex, so if you're diagnosed at birth with a sex, you know, a variable, for example, if you were born with 2 X chromosomes and a Y chromosome, but that is a completely separate issue, and that's not really what we're talking about today. Today is more like a legal gender based on your legal gender identity, separate from any kind of medical diagnosis, which is, you know, it's a good is a good point to say. Unfortunately, it looks like that we will not be able to address every single question today, and that we ran out of time. If we did not get to your question today, you can always submit it or any other questions you have using the Ask a Librarian feature on our website at ask.loc.gov/law. We thank you for your time and attention this afternoon. The next Law Library webinar is on November 21st, and it will cover the review of the 2024 LLC research products and publications. I hope you can make it. Again, thank you so much for your time and attendance.